Hello, good afternoon, and welcome to this, which is our fifth webinar, second one this year, fifth in total. And you'd think we would know what we're doing by now, so we're only 2 minutes late rather than I think we were 5 minutes late last time, but anyway, never mind. Thank you for joining us. For those of you who are watching this live on the webinar, you can see I'm sitting in front of our gorgeous equality banner, because the focus of today is, of course, equality and reasonable adjustments. And for those of you who are watching this on the YouTube link later on, you can just imagine, but I don't know, maybe we'll put a picture of the equality banner on the end of the thing. Yes, Tom's nodding at me, good. Okay, so yeah, thank you. Let us move on with the presentation. So, as ever, before we get started, my usual quick disclaimer. Nothing I'm going to tell you today should be taken to be legal advice. The views are my own. Hopefully they align with the views of the union, but I stress they are my views. And look, if you're in any doubt about anything that we cover today, please do get in touch with your officer or me, and we'll see what we can do to help. So yeah, that's the plan. So what are we talking about today? We are talking about the Employment Rights Act, but not all of it, obviously, because we've talked a lot about it before. But today we're going to be focused on purely those elements of the Equality Act which are relevant from an equalities perspective. And then towards the end, we're going to spend a little bit of time thinking about reasonable adjustments, which is something that, I think we all talk about reasonable adjustments, but I'm not necessarily sure that we all understand them enough to be able to use them usefully in the workplace. So hopefully, if we think about how we could use them, maybe that's going to be useful today. So anyway, let's push on. As always, if you have any questions, please put them in the chat. There's a Q&A field. Some of you hopefully will be able to use that for your questions. If not, please just put them in the chat. My excellent colleague Tom is monitoring both of those for us. So yeah. So one of the things that I'm sorry if you could hear that, the water machine behind us has just decided to give a good old gurgle. But anyway, so one of the things that the Equality Act, the Employment Rights Act has introduced is stronger harassment protections. Now, this has been a direction of travel for this government for quite a period of time. The government has a policy of trying to cut violence against women and girls by half across the lifetime of this Parliament, which I think is an excellent aim, and a number of the things that are included in the Employment Rights Act are with that aim in mind. So from April already, the rules around what can constitute a qualifying disclosure for the purposes of whistleblowing protection were tightened. And what happened was the government changed the list by including in there a declaration to the employer that sexual harassment is happening in the workplace, has happened in the workplace, or is likely to happen in the workplace. That becomes a qualifying disclosure. So I think it's very clear that the government want to see employers taking a stronger line against sexual harassment in the workplace. In October this year, the liability for employers for all kinds of harassment is going to be broadened. At the moment, the employers are liable for the actions of their own employees. But from October, that is going to be broadened out to liability for third-party harassment. Now, this is something I think potentially some employers might be a bit nervous about, because, why would an employer be held liable for the bad behaviour of a customer, for example, in a restaurant or in a shop? But what the law will expect is that those employers have taken reasonable steps and done everything they reasonably can to prevent those customers from behaving in an appalling way. Now, this matters for us because potentially, as a union, for example, we might be liable for the actions of third parties against our colleagues in our offices. If somebody comes in to visit our office, then potentially we have to make sure that the people who visit our offices behave in a certain way. Some point next year in 2027, and I should point out at this stage that pretty much everything I'm saying today that is coming in 2027, we don't actually know when in 2027 any of these things are going to change, because the government's own timeline for implementing these different parts of the Act just say in 2027 we're going to do this. So best guess, probably some stuff in April 27 and some stuff in October 27. But which and when, who knows? But at some point in 2027, there will be further restrictions on the use of non-disclosure agreements to cover allegations of harassment. Now, that's going to be, I think, really important. That for too long there's been a culture within employment of employers being able to throw money at a problem, hush it up, brush it under the carpet. None of that should be acceptable. If there is bad behaviour happening in workplaces, we ought to be able to tell people about it. Since April, for larger employers, they've been on a voluntary basis able to produce menopause action plans and gender pay gap action plans, so to address some of these equality issues in the workplace. And I think this is really interesting area that, for years, women of a certain age have just had to kind of, just deal with the consequences of menopause. But there are a number of things potentially that employers can do, bearing in mind the limitations of the workplace in terms of ventilation, in terms of access to cold water, if that's what helps people. The point is that employers are going to have to kind of knuckle down and get on with this stuff, because it's coming in as a mandatory requirement for larger employers. So what I would say to any of you who are in discussion with your employers around some of this stuff is get them to start thinking about it now. Don't wait until it becomes mandatory and then potentially folks are getting punished for not doing things that you've had the ability to do this voluntarily for some time. And obviously if we can get involved in these discussions early on, then we've got more opportunity to move things in the direction that we would want to see them go. We're also going to see greater accountability for outsourced providers when it comes to there's gender pay gap reportings and action plans. Again, that's not yet certain, because we don't yet know until we get the detail of what will be required to implement this part of the Act, whether the amount of information that employers are going to have to provide really when it comes to those outsourced workers. But again, just watch this space, and we'll update once we know more. We'll share with you. I think one of the important changes that we've seen in the Act is the introduction of more family-friendly rights. That since April, there's already now a right to day one parental and unpaid paternity leave, and I think that's something that good employers for years have given fathers and partners the opportunity to take time off to support the mother with the new baby, and I think that's really, really important. But then sometime in 2027, that's going to be extended even further. That in the case of the death of the mother within the first year, then the other parent is going to have the right to take up to a year of extended leave. I think that's really, it's going to be interesting to see firstly, whether that becomes much of an issue in the workplace. I mean, obviously I hope not, because it would mean that the mother's died, sadly. But for some employers, I think this, I'm not sure people know about this, out there in the wider community, but it's something that's coming in next year. We'll have to see how that pans out. Again, in 2027, there's going to be an extension of the right to flexible working. Now, it's the right to request flexible working. It's not a right to work flexibly. But I think where we've got to over the years with the right to request flexible working is really interesting, because when it was first introduced a number of years ago, it was limited in its scope. It was, limited to those who were parents of children of a certain age, or, older children with disabilities, for example. And then it was extended beyond that. It wasn't just for people with children and caring responsibilities for disabled children. And I think since then we've seen lots and lots of examples in workplaces of members making requests for flexible working. And, as I say, this is just a right to request. And it's pretty straightforward process for an employer to deal with a right to request flexible working. The key thing from the employer's perspective is one of time. You only have a certain amount of time to deal with the request, and you have to get if you allow an appeal, you don't have to allow an appeal, but if you do allow an appeal, you have to deal with the appeal within that time frame as well. And sometimes this can trip up employers because they think, okay, we'll just deal with it. We've got so many weeks to deal with the request, and I'll take my time because it'll look like I've thought about it, and then I'll tell them no. But, really, it is a fairly straightforward process. But that right to request has often meant that really there's just a right to have your request turned down. So from next year, we're going to see, so we believe anyway, we're going to see a bit of a tightening up around the process, and a bit of a tightening up around the reasons why employers can say no. The idea is that it's going to promote work-life balance across more diverse groups, but the key change isn't just about making it harder for employers to say no. The key change is going to be that it'll be a right to request from day one, which I think, particularly for some disabled workers, that if an employer has a particular kind of working pattern that it wants people to stick to, and if a potential new employee from day one can say, well, look, that is difficult for me, but if I can start a bit earlier, finish a bit later, whatever it might be, then I can still do the job, but require that level of flexibility, and hopefully we'll get to the point where the kind of Monday to Friday 9 to 5 rigid regime that still dominates a lot of workplaces. I think where does that come from? Why do we need to cling on to it? Is it sensible? Maybe not. So all of that said, more plumbing sounds from behind us there. All of that said, those rights of flexible work, often what happens is people are making those requests for flexible work when really what they should be asking for is a reasonable adjustment. Now, not in every case, and obviously a worker with a disability is as entitled to make a flexible work request as anybody else. That stands to reason. But if it is the right level of flexibility for the right reason, then it's probably better done as a reasonable adjustment. So what I want to do this afternoon is spend a bit of time now thinking about reasonable adjustments and thinking about kind of when do we ask for reasonable adjustments and how do we ask for reasonable adjustments. And I've got a bit of an 8-point plan here, really. And it begins with understanding your legal position. We'll talk a bit more about that in a moment, or what I mean by that. But then, once we've done that, it's basically that's a question whether somebody has the right to request a reasonable adjustment. Then we need to identify what the workplace barriers or challenges actually are. And then think about what the potential adjustment might be. And then think about what support is there. Is for example, access to work, people like that. And then, only then, make the request. So the idea is that you've already thought about what you're going to ask for. You've already thought about how it's going to work. You've already thought about what impact it'll have on the employer. And then once you've made the request, it's really important to engage with the process, because whilst you've had the opportunity to think about what you want to do, then you make the request and potentially it comes out of the blue to the employer. So give them the time to kind of catch you up in your thought process. Spend some time with them talking about what your challenges are, talking about how the disability impacts, and what the particular difficulties are that the employer's approach puts you to. And then most importantly, keep in mind what reasonable actually means. Remember, the obligation on the employer is only to take the steps it's reasonable to take in the circumstances. And then finally, just keep good written records throughout. So let's just go through those in a little bit more detail, beginning with what is the legal position. Well, first and foremost, the legal position around what is a disability, because we talk about disabilities, we've got people who may have a diagnosis, may not have a diagnosis, may have a formal condition, may have no idea what their particular challenges are. But in a sense, none of that really matters, because you can have a diagnosis of a particular condition that frankly doesn't impact you from one day to the next. That's not going to be a disability for the purposes of the Equality Act. So how do we decide who has a disability for the purpose of the Equality Act? We begin with Section 6 of the Equality Act, which sets out a number of tests which have to be satisfied. Firstly, the first element of the test is that the worker has a physical or mental impairment. Now, physical or mental, it's important when we're talking about both physical and mental impairments. It's important not to get hung up on labels. Again, this is an area where we don't need a formal diagnosis. There just needs to be an impairment. It may be that you're exploring diagnosis. It may be you're not exploring diagnosis. It doesn't matter. What matters is that there is an impairment. And then the definition, kind of the test, I suppose, moves more towards the sort of impact of the impairment. The impact must be substantial, which means that it's more than merely inconsequential. So it's more than just kind of, it's annoying. It's more than that. It has to be more than that. It has to be substantial. And it must be long-term. What do we mean by long-term? Well, there's three elements which go up to make the definition of long-term. One, that it has lasted for 12 months or more. Two, it is likely to last for 12 months or more. Or the third part is that it is likely to last for the remainder of the person's life. So what we're talking about there is somebody who is, has a terminal diagnosis, who is, at end of life care, that type of thing. Then in terms of the effect of the impairment, it must have adverse effects. So in other words, it must negatively impact you in some way. And those adverse effects have to be on day-to-day activities. Now, the focus there isn't what can you do? There's a list of day-to-day activities. Can you do this? Can you do that? And you tick enough off, therefore you're not disabled. No. That's not the right approach. The right approach is on a day-to-day basis, are you impacted by that impairment? Okay, so that's the definition. Having established that you fit the definition, or you are likely to fit the definition of disability in Section 6, and I say likely because ultimately that's a legal test for an employment judge to determine. But an employer must make their own decision about whether they think it's likely that a particular worker is disabled or not. So, assuming that it's likely that the person is disabled, the next stage is to think about what are the barriers or challenges, and then think about the possible solutions, in other words, the adjustments. Now, again, what's the legal test here? Well, Section 20 of the Equality Act places a duty on an employer where, three sets of circumstances. One, where the employer has a provision, a criterion, or a practice, a so-called PCP, provision, criterion, or practice, which puts the disabled worker at a substantial disadvantage compared to another worker who doesn't have a disability. So that's the most common one that we see. The other one is where there is a physical feature of the building. So it could be like an obligation on an employer to provide step-free access, for example, for wheelchair users. And the third one is where the employer is under a duty to provide auxiliary aids. Now that might be things like an adjustable chair, or a particular keyboard, or a certain type of mouse for people who have work-related upper limb problems. So those are the circumstances under which there is a duty to make those reasonable adjustments. Now, it's important to keep that in mind, because in order to persuade an employer that they have an obligation to make a reasonable adjustment, we have to be able to explain what we say is the provision, criterion, or practice that puts the individual disabled worker at the substantial disadvantage. Okay? So what is it about the work that is harder for you compared to your non-disabled colleagues? That's the question that we have to ask to our disabled worker. It could be physical. So it could be lifting, it could be carrying, it could be, as I said before, it could be the meeting room that you have to go to is up 3 flights of stairs and the lift doesn't work, for example. Maybe they're performance issues. Maybe the people are expected to do a certain amount of activity within a particular time. Maybe in a warehouse, for example, you have to fulfill a certain number of orders within a particular period of time, and perhaps, in order to do that, you have to walk around the warehouse and pick the items from various different locations. Now, that's fine if you're young and fit and agile, but the older you get, maybe the harder that is. Maybe you have mobility difficulties. So again, it's about working with the employer to work out what would be reasonable. If a young, fit, agile person can fulfill, I don't know, let's say 15 orders in a day, maybe an older worker with more disabilities, more physical impairments might be able to do 10 or 8, perhaps. Now, would that be reasonable? Well, that very much depends upon the size of the organization. So how could it be different? Rather than a requirement to fulfill 15 orders in a day, could we work with a requirement to fulfill 10? Perhaps there are certain orders that require less walking, for example, that type of thing. And who can help? There are organizations out there that, for particular types of disabilities, for example, there are organizations that can help. somebody who maybe is hearing impaired, for example, then there's a number of organisations you could approach who might be able to help with installation of loop systems, or maybe provision of sign language interpreters, or whatever it needs to be. So then we make the request to the employer and engage in the process. Now, keep in mind here that the objective is to level the playing field. It's not about trying to give disabled workers an unfair advantage. And sometimes what we hear, amazingly how often we hear from employers, no, can't do that, because if I do that for you, I'll have to do that for everybody else. Well, you're kind of missing the point about reasonable adjustments. You're adjusting things for the person with the disability, which removes the substantial disadvantage and allows the disabled worker to contribute to the success of the organisation to the same extent as everybody else. So, yeah. Sometimes, by the way, what we see in terms of reasonable adjustments is that, I'm a disabled worker, I'm likely to have more sick leave than everybody else, therefore I need more sick pay than everybody else. No, that's not going to work. Reasonable to have adjusted attendance targets, that's absolutely fine, but increased sick pay is about keeping people on the sick at home. That's not the purpose of reasonable adjustments. The purpose of reasonable adjustments is to keep people, enable people to be in work more than they would be otherwise. Okay, look, like I said, if there are any other topics you would like us to cover in the future, please do get in touch, let us know. We're more than happy to see what we can do to accommodate them. Bit of a plug as well, we are developing what we hope to be a very successful series of podcasts. And again, we're aiming to make those kind of short, bite-sized, focused, one sort of topic per episode. So again, if there are things that you would like us to incorporate into the podcast series, please do get in touch and let us know. So, thank you to all of you for joining us this afternoon. Thank you to those of you who are watching this but you're kind of looking at my slides and listening to me ramble on YouTube. But thank you to those of you doing that anyway. Thanks to my colleagues Molly and Tom, as always, for enabling me to sit here and talk at you for an hour or so. And I look forward to seeing you all in September. Thank you.